Our special guest for this entire hour, criminal defense attorney and former prosecutor and the attorney for Jussie Smollett, Tamara Walker, joins me now. Tamara, thank you so much for being with me.
Thank you so much for having me, Michael. It's always great to be on your show. I appreciate it.
All right, it is certainly our pleasure. And I know these are difficult times for you representing Jussie. So let's start off with some of the practical things in terms of, as far as you know, how is Jussie holding up?
Well, you know, a jail sentence is always a shock for anyone who has led a crime-free life, especially someone like Mr. Smollett, who's been a constant activist. So he's holding up as well as he possibly can under circumstances that few can imagine.
All right, now, where exactly is he being held right now? There's lots of different reports about where he is. Again, to the best of your ability, there are a number of attorneys representing him, so I know there's limited information going back and forth sometimes. But what can you tell us about where he's being held right now?
Well, you know, I don't want to disclose exactly where because that's a security issue with the Cook County Sheriff's Office, but we are working to make sure that he is held in the most safe way possible, that's safe for himself, other inmates, and his mental stability.
All right, so let's talk about that. Let's talk about the mental stability and this protective custody. At the very least, we know that that was ordered by the judge. So if you can enlighten our viewers what exactly it means to be held in protective custody. What is the day-to-day like for him under those circumstances?
Right. Well, you know, the Cook County Sheriff's Office released a statement that explained exactly what protective custody looked like. And in their explanation, they provided that he would be in a cell by himself, that he would obviously be allowed time outside of that cell, but it would be without the presence of other inmates, and that he would be under monitor by a sheriff's deputy. So while it is definitely designed and aimed to make certain that he's safe, it's also somewhat isolating. And that's what we were referring to in our emergency motion to the appellate court regarding, you know, a stay on the jail sentence or for him to be able to post bail while the appeal is pending.
Tamara, I want to play some sound from his brother, Jussie Smollett. Yesterday, he talked about him being in a psych ward, and there were some concerns. I want to play that. Then I want a couple of questions for you.
So Jussie is currently in a psych ward at Cook County Jail. What's very concerning is that there was a note attached to his paperwork today and put on the front of his jail cell saying that he's at risk of self-harm. I want to just make it clear to folks that he is in no way, shape, or form at risk of self-harm. And he wants to let folks know that he is very stable, he is very strong, he is very healthy and ready to take on the challenge that ultimately has been put up against him.
All right, so how much of that can you verify for us in terms of both the fact that there was this note put on that he was at risk for self-harm, but that is not the case, and in fact, he is holding up well?
Well, you know, the Sheriff's Office is very reluctant to release a lot of details, and that's mindfully so, that, you know, they don't pose any security risk for anyone involved. But I would say that his family has been absolutely amazing.
All right, looks like we lost Tamara there for a second. We'll do everything we can to get her back. In the meantime, why don't we go to a quick break while we work on those technical issues that we're having. When we come back, we're going to discuss the judge in this case. Many of you sat here right here on my show during the sentencing when the judge really went on and on for about an hour talking about this case, justifying the sentence that he was going to give Jussie Smollett. And Tamara will talk to us about that whole situation when we return. So keep it right here on Court TV, your front row seat.
Licensed everything.
I know that there is nothing that I will do here today that can come close to the damage you've already done to your own life. You've turned your life upside down by your misconduct and shenanigans. It's no question. Mr. Smollett was born into a mixed-race family. His mom is an African-American woman. His dad was a white Jewish man. There were 6 siblings. And if you can say anything about this family, and we're talking about a very, very tight-knit family, a village that was always in sync with each other, that cared about each other, was completely, wholly supportive of each other. You know that this family knew about matters about social justice more than anything else. That's what the family stood for. I know that Jussie Smollett grew up knowing to be sensitive to matters about racial discrimination, any kind of discrimination. He's been doing this all his life. He doesn't just talk the talk, he's walking the walk. He's out there, he's advocating. He's involved in the community. He cares deeply about social justice issues. And for you now to sit here, convicted of hoaxing hate crimes, racial hate crimes, and homophobic hate crimes, the hypocrisy is just astounding. But the only thing I can find is that you really crave the attention, and I acknowledge there are wonderful sides to you, but you have another side of you that is profoundly arrogant and selfish and narcissistic. You wanted to make yourself more famous, and for a while it worked. Everybody was talking about you. The lights are on you. You are actually throwing a national pity party for yourself. Hate crimes are the absolute worst. And I believe that you did damage to real hate crimes. I know how people, they cherish you, but you had that dark side. You're just a charlatan pretending to be a victim of a hate crime. And that's shameful, especially from the family you got brought up with your family values. It's so sad. You've embarrassed your valuable friends in high places, the elected public officials, people in the media. You've embarrassed them. You have to live with that. I don't know if those relationships can be repaired. You've turned yourself into riches to rags, and it's so unfortunate. You're the butt of jokes. Comedians, mainstream talk show hosts, they make jokes about you. I can't imagine anything worse than that. No, this is all self-inflicted. All because you're selfish, arrogant, narcissistic. At least you have that side in you. That came out through this case, and you kept doubling down and doubling down and doubling down. It's not funny. It's not funny at all.
The sentencing of Jussie Smollett was filled with as much real-life drama as his former hit show Empire. And some of the theatrics, as you just heard, came from the Cook County Judge James Lynn. Before announcing Smollett's sentence, Judge Lynn methodically went through the chain of events surrounding the hate crime hoax perpetrated by Smollett. The judge also took the opportunity to chastise Smollett with what can only be termed a barrage of insults. All right, still with me, our special guest for this entire hour, the attorney for Jussie Smollett, Tamara A. Walker. All right, Tamara, I want to step back for a second. We'll get to the judge in a moment. Before we got cut off there with a little bit of a technical issue, you were talking about Jussie's current condition and that there's limited information?
Well, obviously, the sheriff's office has to be very protective. Clearly, he has a team of attorneys who, if anything happens to him in custody, will be ready to act. So we actually appreciate the efforts that they're taking to make sure that he is protected, and it's an ongoing conversation between our team and theirs. And, you know, it's the law enforcement field in the correction portion of it is a pretty vast bureaucracy. So it's a lot of steps to it.
All right, and I want to touch on the threats real quick. We know the family says they've been receiving threats regarding Jussie. Do you know if he's getting any threats from within the jail? Is there anyone there that might be threatening him?
Well, you know, because we're in the process of reporting a lot to law enforcement with the family and making sure that the situation is captured in the best way that it can be and is memorialized and is acted upon as appropriate, I don't want to go into a lot of detail, but I will say that it is a multifaceted approach. Because here's the thing, you know, the threat situation has been ongoing while he's in custody and even before, not just for Jussie and his family, for us as members of his legal team. It has been going on for several months. And obviously with him in custody, that's raised the stakes. But, you know, there are a lot of people that for some reason take it upon themselves to try to do harm to, you know, anyone connected with this case.
All right, so my understanding from that statement is that you, the family, everyone, you are working with authorities, because that was the suggestion of the sheriff. We do know that some of the threats, or at least one of the threats, was turned over to TMZ. They suggested, hey, work with authorities, so that is happening.
Yes, we're in the process of compiling all the information to making sure that all of the proper authorities are alerted and take action. Absolutely.
All right, so let's get to this emergency motion to have him released from prison. Tell me a little bit about that motion. I understand that one of the assets, or one of the facets of it involves COVID. That's an area that I think there may be an opportunity for some strong arguments to be made. So tell me about that motion and where it stands right now.
Well, the way that type of motion works, and it's an emergency motion that we filed to, again, either get him a stay on his jail sentence or for bail to be posted while the appeal is working its way through. So with that, what the appellate court wants to see is how strong is your claim for an appeal? Are you just saying appeal because it sounds good, because that's what your client expects, or do we actually have valid grounds that we expect to be granted? And for us, in this case in particular, the reason we filed an 83-page post-trial motion is we absolutely believe we have valid grounds for appeal.
All right, now we're going to go through some of those things coming up in our next block. Right now, I want to turn back to the judge and some of the issues that you have, which included in your motion for a new trial. There are some of the actions of the judge. Quickly, I want to play something from the very beginning of sentencing, which kind of struck me a little funny, and I want to get your thoughts. Let's take a listen.
And there was a tremendous amount of attorney manpower and billable hours that were lost by the Winston Strawn firm. And they did it selflessly. They did it because they thought they needed to do the right thing. All I can say as a member of the judiciary, thank you, because that was very, very extraordinary. And I have no idea what the amount of billable hours are, and I can only imagine, but I think it is huge and truly significant.
You know, Tamara, early on, as we showed you there, he kind of seems to be frustrated with the defense and what I'll call zealous representation by you guys of Jussie Smollett. He seems to be lauding the special prosecutor's offices, the fact that they did this pro bono. I want to know how you reacted to some of those statements, and if in fact my supposition is true that there was some frustration there between perhaps the judge and the defense.
Wow, where do I start? Okay, so how would any practitioner feel in that circumstance? And here's the thing, zealous advocacy, I'll never apologize for. Not a million years will me or any other members of the Smollett team apologize for zealously advocating for our client as we would for any client who ever came into any of our offices. Without question, that is something that is always at the forefront of our representation. So with that being said, what's interesting here, as you point out, and I'm so glad to have the opportunity to speak on this, you know, it was almost as if we were being chastised for being advocates, for filing the appropriate motions, for pointing out the legal theories that we felt applied and the judge should take a look at. That was actually not even quite accurate as to what occurred. Yes, we filed all the necessary motions. Yes, we did everything that we needed to make sure Mr. Smollett's rights was preserved. But the thing is this, a lot of times we were responding to what the special prosecutors put out. You know, they are an international civil law firm. They file a lot of paperwork, a lot of briefings. We, of course, were not going to be negligent in our response, and we did not hesitate to file what was necessary. But here's the thing, you would think that zealous advocacy would be rewarded. So it was very interesting, and honestly, in 21 years of practice, I have never once had a jury trial where the judge thanked one side. And in this case, the special prosecutors were not appointed. You know, Dan Webb volunteered for this with the resources of his international firm. So, you know, while that may have been meaningful to the judge, I feel as if with everything that we went through in this 9-day trial and the years that preceded it, that at the very least, it would have been the gentlemanly thing to do to thank us all.
Yeah, fair enough. And you know, he goes on in his sentencing to, as I called it, with I thought was a barrage of insults for Jussie Smollett. Again, something that I had not really seen before. I want to get your reaction to that part of the sentencing.
Well, you know, I paused for a moment because it's still fresh, obviously, and the tape you all played with the insults kind of all looped together, that was impactful, and it was actually emotional for me still, and I can only imagine how emotional it has to be for Mr. Smollett, obviously, his family very clearly. You know, his mother was in the courtroom, the world was watching, and for him to berate and dress him down and drag him through and, you know, his character, when that was a one-sided version of what happened. Yes, he's been convicted of the offense. It is a class 4 felony that is a level above a misdemeanor. But guess what? He had a number of people advocating on his behalf, including the NAACP, the Innocence Project, Black Lives Matters, a number of celebrities. I was blessed to be able to read the words of Alfre Woodard, who she considers him like a son. And her words were so eloquent, along with Samuel Jackson and his wife, numerous other letters that we submitted. Some of them we read on, for the camera. So it was just difficult to sit there and have that type of, really, to me, it's nothing other than a dressing down. I mean, you're already a convicted felon. You're already facing sentencing, and like the judge said, there's nothing worse he could do. So why are we going through this barrage and complete character assassination? It definitely, and it seems to be the mass opinion that it was excessive, and that was certainly our opinion.
All right, so let's get to the meat of the matter here, the actual sentence itself. It seemed like Jussie had an issue. So I ask you, was there a conversation prior to where you prepared him for the fact that he could be going into jail right after sentencing? And also, I want you to tell me about that response. How did you see that response by Jussie, and why weren't there any attempts to maybe slow him down or stop him?
Well, to answer the first part of the question, anytime you have a defendant who could be facing time, you absolutely prepare them for that possibility. Although to tell the whole story, you have to say that a Class 4 disorderly conduct, filing a false police report, which is what his charges were for all the media hoopla, that's what it boils down to. These cases are often resolved by dismissal, as his case was originally, or they're amended down to a misdemeanor. And I've never seen in my 21 years of practice anyone with no criminal history with that type of charge receive jail. So you prepare them for it, but then there's also this is usually what occurs. You kind of have to present both sides in order to give the full picture. Now, as far as how he reacted afterwards, I don't think it was lost on anyone. And if it was, let me explain. You have a number of people who have gone to jail and have ended up with what was considered to be suicides. Among them, stands out in my mind, is Sandra Bland. You also have Jeffrey Epstein. And in my opinion, he was making the statement that I'm not suicidal. If something happens to me while in custody, please investigate, because it wasn't me. And I think that it's unfortunate that we are at this place as a society, that someone in that position is even having to think that way. But because we can name more than one person, and I'm sure there's countless others, unfortunately, that's where you have to think sometimes.
What do you think, Tamara, would have been the appropriate sentence in your mind in this case?
Well, the appropriate sentence had been given the first time, which was he did community service. He forfeited his $10,000, which is a very large amount for a level above a misdemeanor. You have to look at it like this. In Illinois, the maximum penalty for a Class 4 offense is the probation, and it's also a $25,000 fine. Now, if you give a term of probation, the maximum amount of jail you can get is 180 days. In this case, the judge gave 150. Generally, in a case like this, it would be at most 2 years probation, some community service. You have to check in with the probation officer. At least you would qualify for a diversion program where you complete the terms, generally community service, and then it's as if it never happened. And that is someone with Mr. Smollett's history, thousands of other defendants with a similar history, some of them with worse offenses like domestic battery, that's a Class 4 as well. I've seen people not get any jail time, and that's actually a crime of violence. So I think that we have to keep in perspective what typically happens. I've had these types of cases as charged as felonies, and I was able to get them amended down to misdemeanors.
Well, let's be fair here. I mean, I agree with you 100%. I could find you 1,000 cases where someone with a Class 4 felony did not get any jail time, got probation, restorative justice. A lot of people suggesting restorative justice might have been the right thing here, where instead he goes out, then going to jail, he goes out and he talks to people about it. But I think what angered the judge the most was, in his mind, in the face of what was an overwhelming case by the prosecution, Jussie continued to lie, was not in any way suggesting that he was sorry for what he had done or taking responsibility for what he had done. It was a very high-profile case. So in his mind, that probably wouldn't have been the right way to go. This was not a young man who was, in any way admitting to what he had done or was convicted of doing.
Okay, so here's the thing, and I'm so glad to have the opportunity to say this finally. There was no smoking gun in this case. The bottom line is this. You either believed the state's version that they put forth with the Osendero brothers, or you believe Mr. Smollett. Clearly, the jury and the judge agreed with the prosecution's evidence that they presented. However, let me be very clear. There was never a videotape where Mr. Smollett was saying, let's put this plan together. There was never an audio tape. There was never a text message. There was no smoking gun whatsoever. The bottom line is, again, in the face of years of media coverage that was ridiculing Mr. Smollett, popular comedians ridiculing Mr. Smollett, the now disgraced former chief of police assuming as if he was judge, jury, and executioner before Mr. Smollett had even been charged, it was difficult, very difficult to overcome that. When we've had jurors who were interviewed who've said things since the trial, since the conviction, they've said things that definitely suggested that there was reasonable doubt. They chose to convict anyway. So it's certainly the trier of fact's right to decide, I believe this person over that person. That doesn't mean that perjury was committed. That's actually what the judge said. Doesn't mean perjury was committed, especially when there's no evidence to say definitively, well, he did it because of this. No, there wasn't in this case. So.
All right. So now you may have addressed this already, but maybe go a little bit deeper, because I'm you, given all the information that you're giving me, why wasn't the defense able to create some reasonable doubt? I read a lot of the transcripts. You sent me those, and I thank you for that. I read a lot of the transcripts of the testimony of one of the Osendero brothers. There was a lot in there to work with. I saw your cross-examination of it as well. Now, again, we weren't privy to the whole thing because it wasn't televised, but I want to get your thoughts specifically on why you were not able to create that reasonable doubt.
Well, like you said, I just alluded to it in my previous answer, which is it's very difficult. When the police chief gets on TV on Good Morning America and says Jussie owes the city an apology before he's even been charged, you know, he set the stage, set the scene for a conviction. We weren't able to question jurors in the way that we wanted to. That was one of the issues that we raised in our post-trial motion. We weren't able to question jurors at all. And even the questions that we submitted to the judge to ask, he didn't ask them all. You know, we had a number of areas of concern with picking that jury that we raised that the state was, and when I say the state, the prosecution was striking jurors for discriminatory reasons. They struck 4 out of the 5 black jurors that were potentially could be on the pool, and an openly gay man as well. So it was exceedingly difficult under those types of circumstances, because like you said, and I appreciate the, you know, the fact that you led credit to the fact that we actually did raise reasonable doubt. You know, whether or not that reasonable doubt was able to overcome the presumption of guilt that had been going on for years before our case started, obviously not. But that doesn't mean that we didn't raise ample reasonable doubt in this case.
Yeah, and I didn't say you created reasonable doubt. What I said was you impeached a lot of his testimony, which if a jury was inclined to do so, they could certainly find some reasonable doubt. So I don't know, again, we trust and respect the jury system. All right, stand by. We're going to take a break, Tamara.